to get started on the number and the meaning and crazy stuff like that, but it's eerie. It's very eerie. The both of them involve scholar transport, extreme risk taking that resulted in children dying. Large outcry from the public saying charge them with murder. Did the driver accept death as a possible outcome, or did they believe nothing would happen? In both cases, I would argue. Hey guys, today I'm going to go over the Vanderbijlpark case with y'all. For those who don't know, that's the case that's been in the news lately about the taxi scholar transport. The guy was transporting kids to school, 14 kids. 12 of them died while he was trying to overtake and ended up crashing into a truck. So a lot of people look at this case and say, well, that's obviously a case of murder, right? The guy was negligent, reckless driving, the usual stuff we see every morning when we get to work. People are like, yeah, another accident, taxi, this guy overtook me, this guy pushed me off the road. You of course think, well, this is directly going to result in a charge of murder for the guy who was driving, a 22-year-old who survived. In fact, him and his sister survived. But that's not necessarily the case. There is precedent that's been set previously in other court cases. There was one specific one that says that he may actually not be charged with murder or even attempted murder because of something called dolus eventualis. In South African law, there is a case called the State versus Humphreys.
Humphreys was convicted last year after his taxi was hit by a train when he jumped the Butskop level crossing at Blackheath in 2010. 10 children died and 4 were injured. Humphreys stood stone-faced as his sentence was read out, but there were audible gasps from the public gallery. Defence advocate Johan Engelbrecht's request for leave to appeal the conviction and sentence was dismissed.
It was decided by the Supreme Court of Appeal. In this case, Humphreys, which is obviously his surname, was a school transport driver who drove a minibus carrying children over a railway crossing. When he approached it, the boom was down, which means there's a train coming. The boom was down, the warning lights were flashing, and there was a train approaching. But he decided to go around the boom and try and chance it, and the train hit the taxi and killed 10 of the 14 kids who were on board, and then seriously injured 4 of the kids, including Humphreys himself. He was also injured. He was charged with 10 counts of murder and 4 counts of attempted murder. He was found guilty and that he acted with dolus eventualis, and then he was sentenced to 20 years of imprisonment. So this is what you expect, right? Obviously, open and shut case. The guy was reckless. Why would you go around a boom? You have kids with you, you should go to jail. But it's not as simple as that, and this is where the law gets interesting and controversial at the same time, because the core legal issue here, and by legal issue I just mean the core issue that's argued in terms of law, not in terms of emotion, not in terms of right and wrong. That's the part which people get wrong. It's not about right and wrong, but just the law is, did he have intention in the form of dolus eventualis? 3 main kinds of dolus. The 2 which I can explain to you to give you a better idea is dolus eventualis and then dolus directus. So eventualis is, did you know that eventually it could lead to death? And then dolus directus, which is obviously intention, direct intention. Intention is dolus in Latin, and then directus is director. So did you have the direct intention of killing someone? So that's just normal murder. Like that's those, like you go out with a gun, you find someone, you kill them. Dolus directus. There's no disputing that. So on this one, the legal question was, did he have dolus eventualis? There's a cognitive component. He did fulfill it, Humphreys, which says, did he subjectively, not objectively actually, so it's not actually the reasonable person test, subjectively. So did he, in that specific situation, so there's 2 types of tests. There's the objective test, which is in certain crimes the court to ask, would any reasonable person have foreseen this? So anyone who's just in their normal mind and who's not a minor or child or something and who's not mentally disabled, would they have seen this result happening? But then in murder and dolus eventualis, there's usually the subjective test, which is, did this specific person who was doing this specific action, which is driving, did he foresee that this could result in death? And they found that to be true. Yeah. So the court said, yeah, they did. The second one was, did he accept this risk? And they found that, yeah, they did. So he appealed. He went to the Supreme Court of Appeal. That's the SCA for short, which is a court which you basically go to if you've been convicted of something and then you want to overturn it because you believe you've been wrongfully convicted. So that's called an appeal, and then they'll re-look at the facts and everything, and then you could get off, or you could, sometimes it could be worse than the first conviction. But anyway, they overturned it, and that's like a higher court. So he was probably tried at the high court, because you get the magistrates court first level, high court second level, SCA, Supreme Court of Appeal third level, then it's constitutional court. They overturned it, and therefore, because it's higher than the court where he was, it actually overrides that. And they said he didn't meet the second criteria. So the first one was obviously, did he foresee that this could end up in death, which is obvious. Yes, he had to, because he was crossing a railway crossing and there was an oncoming train. There's nothing you can say about that. But the second one is, did he reconcile himself to that? Was he fine with if that was the result? And the reason they said no to this one is because he was in the taxi. So in order for him to have reconciled those kids dying and saying, well, this is fine if they die, he would have had to also say, it's fine if I die. So this was so interesting, because it's like, it shows how this is more of a mental state than the act of recklessness. So that's what they question, the mental state. Not what was done, but what was being thought or what was being intended when it was being done. So therefore, he wasn't also fine with it hitting the kids, and therefore he thought he would get away with it, basically, which is funny that's the reason why he's not guilty. So they said he didn't accept his own death, and therefore he couldn't have been found guilty. And if those criteria aren't both met, then it's not dolus eventualis, and therefore cannot be murder. There was also a second reason. There was evidence found that he had crossed the same railway place and done the exact same thing successfully twice. You would think that would make it worse. Like, hey dude, you've done this twice and now look. But it actually proved that in his mind, he's gotten away with it before, and therefore he's confident now that he'll get away with it again. And therefore that just doubled down on the fact that he did not reconcile himself to the fact that they might die. As far as is concerned in his mind, there's no way we're gonna die. I'm getting over this railway thing and I'm gone. So yeah, that's why. It was judged as overconfidence, not intention to kill. And thus the final outcome was, the SCA said it's not murder, it's not attempted murder, it's culpable homicide. So that's just like, he's responsible for the death, but he didn't cause it. You know what I'm saying? He intentionally, because for murder, intentionality is a must. Otherwise, it's culpable homicide. The crazy part now is the striking similarities between these two cases. This one happened in 2013, and now this one in 2026. So that's 13 years. Which is, yeah, I don't want to get started on the number and the meaning and crazy stuff like that. But it's eerie. It's very eerie. Both of them involve scholar transport. Both of them involve extreme risk taking. Both of them involve they resulted in children dying, and then both of them had this large outcry from the public saying charge them with murder. So basically that's why I'm saying we can sort of use this as a case study, and it might probably be used as a case study by his lawyer, as a case law by his lawyer, to reduce his sentence. In both cases, the legal question is, did the driver accept death as a possible outcome, or did they believe nothing would happen? In both cases, I would argue the answer is they believed nothing would happen. That's pretty much the only reason they would do it. It's even worse in this specific situation because he had his sister in the transport. So then it adds even more credence to the fact that he did not intend on anyone getting killed. He did not reconcile himself to the fact that anyone would be killed. Yeah, this is completely tragic, and I'm only creating this video to just bring some sort of awareness to the law and how it actually works, because people have a misconception. But and there's also another big misconception about how boring it is because you're pushing papers. But it's very useful in everyday life. Some interesting things that this brings up for you lawyers, non-lawyers, is that intention is about the mind and not the outcome. So death alone doesn't prove murder, and courts must prove what the accused thought would happen, what he accepted mentally or she accepted mentally. That's the proof, not the death, not the action or the actual death itself. Recklessness is not dolus eventualis. It's not the same. It doesn't equate to dolus eventualis. So being stupidly reckless and endangering lives doesn't automatically, or ending lives doesn't automatically mean murder. So I knew it. If you say something like I knew it could happen but didn't care, it needs to be separated from I thought I would get away with it. You see, it's two different states of mind, and those states of mind are actually what gets you convicted. Overconfidence can save you from a murder charge, like legit. Thinking I'll be fine can actually reduce your sentence, so that's crazy. But that's the law. Confidence works against intention. Actually, that's what it means. Attempted murder and murder requires intention, always requires intention. You can't almost intend something. It's either you intend to do it or you don't intend to do it. You can't be like, well, almost I kind of intended to do it. It has to be proven. So that being said, I guess the real question is, do you believe that recklessness should be charged as murder? Especially extreme recklessness, not just like, yeah, you know, I was driving over the speed limit, but like extreme recklessness, should it be charged as murder? I'm interested to hear your comments on this. So leave your comments below, and then I'll hit you with another interesting law video. There's so much happening in the country, man. It's crazy. Yeah, thank you for watching. Hope you found this educational and added some value. Yeah, justice doesn't always look like punishment. The law is a wild thing, man.